My name is Jenny Egan. I'm a fellow in the Education and Employment Department at the National Women's Law Center. We got a question from a student who was pregnant and said that her school had forced her into an alternative school, and she wanted to know if there was any law that protected her. There is. Title IX is the federal anti-discrimination law that bars sex discrimination in all schools that receive federal funds. That includes virtually all public schools in the U.S. And Title IX, because it bars discrimination on the basis of sex, also protects pregnant and parenting students from discrimination. So schools are allowed to have alternative programs, and they can provide alternative schools for pregnant and parenting students. The deal is that those programs have to be completely voluntary. So your school can tell you about those programs and they can provide them, but they can't urge you and they can't pressure you, and they certainly can't force you to attend one. The other thing is that once you voluntarily choose to participate in one of those programs, you have to have equal educational opportunities once you get there. So schools on alternative programs for pregnant and parenting students have to have equal access to rigorous coursework and extracurricular activities. Schools can't force you into an alternative school where all they give you is parenting classes and no real opportunity to graduate or to move on to a higher level of education. So Title IX protects pregnant and parenting students. You can't be forced to attend an alternative program. It has to be voluntary, and once you get there, you have to have equal opportunities and good coursework.